Good morning, and thank you all for being here today to discuss the issue of incarceration of children in prisons in India. This is an important issue that even within the juvenile justice space doesn't always get the attention that it deserves. My name is Diksha Gujral. I'm the India Program Director of iProbono, a legal justice NGO that focuses on child rights. We provide direct legal support and psychosocial support to children. We engage in advocacy and legal research, and we provide capacity building support to our partner organizations. It's so fantastic to see so many important stakeholders in the juvenile justice system here with us today. It's important that you're all here because this is an issue that I feel requires some conversation to take place, and I hope that this report will help us have some necessary conversations and some moments of reflection. I hope we also are able to identify some of the causes and possible solutions in order to ensure that no child is ever incarcerated in a prison where abuse, trauma and exposure to hardened criminals is inevitable, and where it's so much harder thereafter for these children to be rehabilitated effectively. I'd like to thank Justice Bhat for being here today as our guest of honor, as well as the respected panelists. I'd also like to specifically thank a child in conflict with the law who is here today to launch the report and tell us her story. And finally, I'd like to thank the team, Gitanjali, Yamina, Krishna, for all of your hard work in putting this report together. It's really been a labor of love and an exercise that I feel is very necessary and has resulted in a report that really makes one stop and think for a moment. Let me hand over the stage now to Gitanjali, the lead researcher and author of this report, who will discuss some of the data with you. Gitanjali is an advisor to iProbono. She began working on this report when she was working at iProbono 2 years ago, and has now completed it in her work, in her personal capacity, in a voluntary capacity. So we thank her for her contribution here. She currently works at Azim Premji Foundation's Access to Justice vertical, and prior to this, she was a Constitutional Values Fellow at the School of Democracy. Her work in this report has brought some truly shocking data to light, and I'll hand over the stage to her so she can share that with you. Thank you.
Thank you so much, Diksha. It's a privilege to be here with you all and to present the findings of this RTI study that Yamina, Krishna and I have worked on for now exactly the last 2 years. For any kind of research that is guided by an intent to inquire into data that can be relevant, one doesn't really know what will emerge. And certainly when you're in the process of doing it, one doesn't have a sense of what the outcome could look like. I'm really grateful to you all for being here because when we began to get our responses, we realized how grim and urgent sort of the data was. And while we had a very iterative process, we quite quickly, after getting the first few RTI responses, decided to make this from a study based on Delhi and 3 other states where iProbono had a presence to a pan-India study. This sort of was born out of, I think it's important to mention, a discussion that Anant Asthana, who requires very little introduction in this room, and I had with Krishna when we were mentoring him during his Justice Leela Seth Fellowship with iProbono. And that's where the 2 research questions that you will shortly see emerged. In January 2022, that year, the Delhi High Court had in a matter shared that the Delhi government's response to a query that the court had, very discombobulated sentence, but the Delhi High Court shared that the Delhi government reported that 800 children had been transferred out of Delhi's prisons in the last 5 years. And that's where we sort of got a sense of the time period that we also wanted to look at, which was 6 years. We began by drafting and filing RTIs on these 2 points of interest. The first one is quite self-explanatory, but the second one relates to the statutory obligation of JJBs under the JJ Act 2015 under section 83M on its functions and responsibilities that states that JJBs shall conduct regular inspections of jails that are meant for adults. I mean, jails are obviously just only meant for adults. We keep emphasizing this point of adult prisons just to sort of emphasize it. And they're meant to check if any child is lodged in these jails and immediately take measures for transfer of such children to observation homes. And we wanted to see if this is happening or not. There are, of course, under the 2022 SOP of NALSA, requirements also that district judges who are the chairpersons of DLSAs also visit jails as jail visitors and take note of this. But because that came later, we wanted to evaluate something that had already been in the law quite clearly for a few years now. So this is a map that sort of captures the response rates from district and central jails across the country. This is where I'd like to point out the limitations of the study. It doesn't by any means cover all prisons in the country. There are sub-jails, open prisons, women's prisons, that are, special prisons, over 700 that we didn't even try to get data from. We just focused on district and central prisons. And the response rate is, I know it looks quite fishy, it's exactly 50%. But I assure you that is after checking and rechecking numbers a number of times. So that means that we're looking at data that is literally from half of only district and central jails, and only constitutes those juveniles who were both identified and then went through the entire process that, as you learn from the panel, is never a speedy or smooth one, to then be transferred to a juvenile home. And so whether to say that this number of 9,681 children who are confirmed to have been transferred from district and central prisons to juvenile homes, whether it's the tip of an iceberg, the tip of an ice cube, it's difficult to say, but I think anybody who's worked in the JJ system understands, and anybody who has spent time in prisons understands that the numbers could be literally in the thousands. But this is confirmed data from prisons. And that is Krishna, who filed the 124 RTIs that form the backbone of this study. So of the 12 states with the highest prison populations, despite a response rate of only 51%, Rajasthan had the highest number of JJB visits over the 6-year period. 18 jails had responded, and it averages out to about 10 visits per prison across 6 years. In reality, for most states that responded, JJB visits were fairly nominal. There were multiple states that had 0 JJB visits. The most staggering numbers were actually, we're missing the slide, I think, on the 9681, but that's okay. The most staggering numbers were from Uttar Pradesh at 2,914 with a 71% response rate. And following that was Bihar with 1,518 with only a 34% response rate. I just want to add a small field note here from a different study many years ago when a small team and I from Center for Equity Studies were at a prison in Banda, and also going to every single police station in Banda to interview SHOs and officials from different levels of the police hierarchy on plea bargaining cases. So the issue was quite different, but when we happened to arrive at this rural police station in Banda, the SHO was sitting on a desk, and there was a boy crying in the lockup. And he was a boy. It was, visible, evident to everybody that he was a boy. And the SHO had a wooden patta on his table. And with nail polish, on one side of the patta, it said, "Ro mat." And on the other side, it said, "Phir milenge." And, it was so grim. But the SHO was unmoved by the fact that we were there as a research team from the NHRC. He said, "आप हमारा क्या ही बिगाड़ देंगे? मेरे लिए एक फाइन का नोटिस आएगा 500 रुपए का, वो ड्रॉअर में पड़ा रहेगा, मैं तो रिटायर करने वाला हूँ, कितने आ चुके हैं और जा चुके हैं, मैंने तो एक की भी पेमेंट नहीं करी है आज तक." And so I think what these numbers are really highlighting are that there is impunity at so many different checkpoints, right? You can call it acts of omission, but Justice Sikri in his 2012 Delhi High Court judgment also said it's not just omission, it's also deliberate acts. And that has been acknowledged by our courts. And so So yes, I mean, it would be excellent to be able to get more data. We had two very, very glaring gaps in our data. Madhya Pradesh, that has 52 district and central prisons, did not send even one response. Despite us going up to a second appeal at the CIC, we haven't heard back from our second appeal. The same with West Bengal. We went up to a second appeal and never heard back. And Odisha, which is also a state with a very large prison population, had only a 6% response rate. Moving on to this slide, which is a slide that represents the data that we got from Delhi. From the same, sorry, previous one, Abhishek, thank you. So this captures the numbers that we received from the prison department for actual number of children transferred. And based on Justice Sikri's directions issued in the 2012 judgment, we also asked for data from the Delhi Legal Services Authority and the NCPCR. This is because both were directed to have regular visits in prisons and to take note of how many children have been identified as possible juveniles. And there's a fair difference in terms of number of visits and number of children identified. This is all, I mean, it's speculative to say, you know, they identified these many. Was age determination done for all of them or not? One doesn't know. But this is just this sort of represents what we received. We can move to the next slide. Thank you, Abhishek. This is data that we had not requested, but that we got from jail number 5, and it tells us a lot. It tells us that only 22 children were identified and transferred within a week. 93% spent up to 3 months. And there are multiple children who spent, you know, I think when I say multiple, I mean, what is a reasonable period, right? It's difficult to say what is acceptable. Nothing is acceptable based on the law. These are all illegal detentions. And the period of time can only tell you for how long a child is being subjected to possible physical and mental trauma. And these are only the children that have been identified. Jhunjhunu jail in Rajasthan, district prison, also provided us this data. It's a much smaller data set of 16 children, but they also told us how long each child was present. This would be a very important data point to actually ask for, and we regret not having thought of it when we were filing the RTIs, but it was too late once we had filed all of them. Next. Thank you. So this is just a sample RTI response so that you get a sense of what we received. It's quite hard to see. Abhishek, is it possible to enlarge a little bit? If it is. What this is showing you is, so it's saying, it's giving you the year and the number of children transferred. This is quite a strange response that we received. It was from District Prison Karnal in Haryana. And the number of children identified in a year by the JJB corresponds perfectly with the number of children transferred. So it is difficult to take at face value, but we have taken all RTI responses at face value. There is no other way to you know, we can't send them responses saying, are you sure this is the correct response? And please provide an explanation for how you've shared this with us. But this is what we would call, aside from these numbers being a bit odd, a complete response. This is all the data that we had asked for. The dates of the JJB visits, the number of probable juveniles identified, and then the number of juveniles actually transferred every year. We can move to the next slide, please. Thank you. And just another note on Karnal, we then also filed from all the states where we received responses saying there had been JJB visits. We also filed RTIs to request the minutes of the JJ visits, but we didn't get a single response when we asked for minutes. This is a sample of a nil response. So this is Central Prison Varanasi, and you know, it's an enormous central jail. It's difficult to accept that there are no juveniles there, but no juveniles were transferred in the 6-year period. Nil, 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 nil for each year, and nil for JJ visits as well, and probable juveniles identified. Thanks, Abhishek. We can. thought to share this quote largely because Sheila Barse has done so much in the space for us to be talking about this and for us to acknowledge how important this issue is. And I think in this quote she's also identifying the crux of why these numbers are so high. Because these are kids who are vulnerable, who are marginalized, who don't have resources, who don't have anyone to vouch for them, who don't have anyone who can push the system because, frankly, they are not seen as children with equal rights, other than by, select actors within the criminal justice system, many of whom are here today. And so just before I end, I want to sort of acknowledge a few things and share a couple of ideas. We have talked about the limitations of the JJ system, for instance, how there just isn't enough infrastructure in many states. So no observation homes or places of safety that children can easily be sent to, and that's often cited as the reason that children are sent to jail instead. But that's insufficient as a reason. Maharashtra, for instance, has 54 observation homes in a state of 36 districts, and it is it still has, based on the very limited data that they shared with us from 30-something% district and central jails, they still had 34 juveniles transferred. So this can't ever be put aside as simply the problem of infrastructure or resource. But another thing that sort of becomes evident while looking at this and looking at judgment after judgment that identifies this as a problem from a Supreme Court and from high courts is that perhaps what is required and what we will look to all of you for, many of you here have been doing this consistently for years, but it is to activate more local ecosystems and build accountability sort of ground up, because there's only so much that top-down directions are clearly achieving. And perhaps we need to reach out to colleagues, friends who work across the country, who have been working on this issue, and think about how to operationalize responses at the local district prison, the local central jail, and perhaps that could make some difference in the system. Certainly in Delhi, for the legal aid work that has taken place, it's because of the commitment of a few individuals who come together and push for that kind of change and change the norms of the ecosystem. So we hope to be engaged with more of that, and we'd of course welcome feedback and are happy to share more disaggregated prison-wise data with everybody. We can make that public on the website, collate it and make it public on the website. Before I end, I just want to take just a couple of minutes to thank my two main collaborators, Krishna and Yamana. Krishna, it was no easy task filing those RTIs, adapting to the requirements and all the responses, and being on top of next steps. And it really, like I said, formed the foundation of this end result. And Yamana, it's been a pleasure to work with you. You've been so meticulous with your attention to detail and following up on everything. And there were RTIs just continuing to trickle in that we wanted to include in the data set till the very end. And so that was also really essential to what you see. We'd also like to thank Shalanki for her support in drafting the RTIs and the very high pressure task of recounting responses. Diksha, thank you for being incredibly patient with my shifting deadlines on this voluntary undertaking. And you really held everything together, so thank you so much. And finally, just in terms of the report and how one absorbs the data, it's extremely grim information, but Richa and Sana just made it look beautiful, accessible, to just be able to read and understand. So thank you very much. We're very grateful that Rashmi is here to release the report, and Diksha will now introduce her. Thank you. Thank you all so much for listening so patiently, and we hope you read the report.
Great. Thank you, Gitanjali. So now, to launch the report, we have who I consider the most important stakeholder in this conversation, a child in conflict with the law who has spent time in an adult prison. So, रश्मि अब हमें बताएंगे कि उनके साथ क्या हुआ था उनका अरेस्ट कैसे हुआ, वो 6 साल उन्होंने दासना में बिताए, दासना जेल में, उनका वहाँ एक्सपीरियंस क्या था, और फिर हमारा रिपोर्ट लॉन्च करेंगी। थैंक यू रश्मि आज आने के लिए और अपनी कहानी बताने के लिए। थैंक यू।
आप सभी को मेरा नमस्कार। मेरा नाम रश्मि है और मैंने अब से 6 साल अपने पिछले जेल में गुजारे हैं। अब से 6 साल पहले मेरी अरेस्टिंग हुई थी और अरेस्टिंग के टाइम मेरी एज 17 थी, 17 थी। मुझे अडल्ट जेल भेज दिया गया, पर अरेस्टिंग के टाइम मेरे से मेरी एज पूछी थी, तुम्हारी अपनी एज बताओ। मैंने कहा 17, तो उन्होंने 19 डाल दिया उसमें। बोले कि नहीं, जो भी तुमसे कोई पूछेगा या कोई कुछ भी कहेगा तो तुमको 19 ही बोलनी है। मैंने कहा नहीं सर 17 है, तो मैं 19 क्यों बोलूँ, 17 है। तो उन्होंने मेरी नहीं सुनी और मुझे जेल भेज दिया। जेल जाने के बाद मेरे पास कोई प्रूफ नहीं था, कोई सपोर्ट नहीं था कि मैं इनको दिखाऊं कि मेरे पास कोई प्रूफ है कि मैं 17 हूँ, या फिर मेरे पास कोई सपोर्ट है जो मुझे सपोर्ट करे कि मेरी एज क्या है और क्या नहीं है। पर कोई नहीं, साल गया, 2 साल हुए, 3 साल हुए, मेरा दिमाग एकदम ख़त्म हो गया था कि मेरे साथ आखिर हो क्या रहा है, या फिर मैं हूँ कहाँ, या मुझे क्या करना चाहिए, मुझे किससे कहना चाहिए। कुछ नहीं था, ब्लैंक हो गया था दिमाग एकदम, और अंदर कुछ नहीं था। फीलिंग्स जैसे ख़त्म हो गई थी, किसी के लिए रोना है, हंसना है मुझे, या मुझे हंसी आ रही है, रोना आ रहा है, कुछ नहीं था, सब कुछ ख़त्म हो गया था। उसके बाद अंदर जेल के अंदर भी बहुत सारे जज आते थे, मजिस्ट्रेट आते थे, बहुत सारे लोग आते थे। मुझे सजेस्ट किया किसी ने कि ना इनसे बोलो तो ये तुम्हारी सुनेंगे, ये करेंगे कुछ, क्योंकि वो करने ही आते थे। वो कहते थे अपनी प्रॉब्लम्स हमें बताओ। मैंने उनसे कहा कि सर ऐसे ऐसे मेरे साथ ऐसे हो गया और मेरी एज 17 है। तो उन्होंने कहा कि ठीक है हम देखते हैं, और वो चले गए। मुझे लगा कुछ होगा, पर कुछ भी नहीं हुआ। फिर से वो लोग आए, और लोग आए, बदल के आए, और मतलब अच्छी अच्छी पोस्ट पे जो लोग थे वो सभी लोग आए। मैंने सबसे बोला कि सर मेरे साथ प्लीज़ ऐसे हो गया, आप कुछ करिए। कि ठीक है हम कर लेंगे, बट कुछ नहीं होता था, कुछ भी नहीं। पलट गई थी एकदम लाइफ, और माइंड एकदम ख़त्म हो गया था कि होगा क्या आगे। रात और दिन पता नहीं, खाना सोना पता नहीं। वहाँ पे एनजीओ है, जेल में था एनजीओ, मैंने वहाँ थोड़ा समय बिताया। वहाँ पर भी टेंशन था, पर ठीक है, वहाँ पे टीचर्स थे, अच्छे थे लोग वहाँ पे एनजीओ में, तो ठीक है वहाँ पे भी हो गया मेरे साथ। कुछ टाइम में फिर iProbono की टीम आई, जो कि जिस वजह से आज मैं हूँ यहाँ पर आपके सामने। अगर बोलने के भी काबिल हूँ तो शायद इसी वजह से, नहीं तो शायद लगता है कि मेरी ज़िंदगी आज भी वहीं होती, उन 4 दीवारी में, या इधर से जाना उधर से जाना, वापस वहीं पे आ जाना। ये मेरी लाइफ हो गई थी पिछले 6 साल से। और 6 सालों के अंदर मुझे लगता नहीं था कि हाँ कभी शायद बाहर का भी मुंह मेरे को देखने को मिलेगा। अंदर ख़त्म हो गई थी सारी होप। लगता था कि अभी यहीं मर जाना मुझे, और कुछ है ही नहीं। लास्ट में सिर्फ यहीं पे है, एंड है, ख़त्म हो गया। 6 साल ख़त्म हो गए। बचपन मेरा था, वो बचपन तो पता नहीं कहाँ चला गया। अब शायद बुढ़ापा आ गया था अंदर, तो वो भी ख़त्म हो गया था। iProbono की टीम आई, उन्होंने मुझे समझाया। थैंक यू यामिना मैम और श्रुतिका मैम सबसे ज़्यादा, और पूरी iProbono टीम, जिनकी वजह से आज मैं हूँ यहाँ पर। उन्होंने मुझे समझाया कि नहीं ऐसे नहीं, ऐसे हो सकता है, तुम बाहर जा सकते हो, और तुम तो गलत इसमें रह रहे हो इस जेल में। तो उन्होंने मेरे को बहुत सपोर्ट किया, और मैं आज आपके सामने हूँ। और बस लास्ट में एक चीज़ और थी, मैं वहाँ पे ना डेट लगते, तारीखें लगते हैं हर 14 दिन में। तो वो चीज़ मुझे बहुत अच्छी लगी थी कि मैंने 5 साढ़े 5 साल मुझे तारीखें लगाते हुए हो गए थे एडल्ट वाले कोर्ट में, डिस्ट्रिक्ट कोर्ट में। वहाँ पर कोई भी नहीं आता था मुझसे मिलने, पर सब लोग मिलने आते थे, उनकी फैमिली। और बट मुझसे मैम मिलने आती थी। सॉरी, थैंक यू।
थैंक यू सो मच रश्मि, बताने के लिए कि आपके साथ क्या क्या हुआ और आपकी एक्सपीरियंस क्या थी। अगर आप राज़ी है तो गीतांजलि आपको एक कॉपी देंगी रिपोर्ट की और यामिना के साथ, और आप रिपोर्ट लॉन्च कर सकते हैं. थैंक यू सो मच. यामिना, आप और गीतांजलि अगर रश्मि को एक कॉपी दे सकते हैं लॉन्च करने के लिए रिपोर्ट. थैंक यू सो मच. थैंक यू. I'd like to just thank you, Rashmi. If we can have the panelists on the stage for the panel discussion at this point. Thank you so much. Great. I'd like to once again thank the panelists for taking the time to share their experience with us and discuss this issue with us. I'll be asking them a series of questions and request that the audience retain its questions till the end when we'll have time for a question and answer round. Let me quickly start by introducing our panelists. We have Mr. Arul Verma with us today. Mr. Verma joined the Delhi Judicial Services in 2009. Since then, he's held a number of different posts. He was the principal magistrate of a juvenile justice board for over 3.5 years. He was also been the special judge for NDPS cases, and he currently acts as the secretary, Delhi High Court Legal Services Committee. He is particularly invested in curbing the use of narcotic substances, recognizing the role that drug use has in recidivism in children. Mr. Verma will be able to share the perspectives of the JJB given his time there. Mr. Amod Kant is here with us today. Thank you, sir. He's a social activist and the founder of the NGO Prayas JSC Society, which he founded in 1988. He's now currently its General Secretary. He's also a former DGP, bringing with him a vast knowledge of the police system, and he's also the founding chairperson of the Delhi Commission for Protection of Child Rights, the DCPCR. Mr. Kant also contributed to the drafting of the Juvenile Justice Care and Protection Act 2000. Mr. Kant will be able to share his insights as a former police officer, as well as the former chairperson of the DCPCR. No conversation on juvenile justice is complete without Mr. Asthana, who is a New Delhi-based child rights lawyer. Anant has years of experience litigating these issues, and many of the judgments he's been involved in have shaped the law as it stands today. He played an instrumental role in developing guidelines passed by the Delhi High Court in the writ petition 8889 of 2011 of the Delhi High Court. He's also been a source of guidance and support, as Gitanjali mentioned, to iProbono when we began our work on juvenile justice and for the entire duration of this study. Mr. Asthana will give us an insight into the legal aid systems for children in conflict with the law and his experiences having worked in the space for this long. And finally, we have Mr. Sunil Gupta, who worked with the prison department for over 20 years and retired as law advisor to the Office of DG Prisons. He was a member of the drafting committee of the Delhi Jail Manual, which gave jail superintendents the responsibility of identifying children lodged in their prisons, as well as the Delhi Prison Act 2000 and the Model Prison Manual 2004. He's also an author of the book Black Warrant, Confessions of a Tihar Jailer. Mr. Gupta will be able to make comments on the failings and responsibilities that should be attributed to prisons. So, when we start the conversation, I think one of the pivotal judgments in the space, as I mentioned, was 8889. There have been a number of judgments of the Supreme Court and the High Court, as well as NALSA standing operating procedures on access to legal services to prisoners and the functioning of prison legal aid clinics. All of these have laid down various different guidelines that are relevant to children in conflict with the law and try to prevent the process by which they end up in a prison. And once they're in a prison, lay down guidelines for them to be identified. These include instructions to IOs, to the magistrate before whom the child is produced, to the JJB, to the DSLSA, to the NCPCR. But the thing is, on the ground, none of these directions are really working, which is why we have such a large number of children who wind up in these positions. Mr. Sana, one of the judgments that is the most seminal in Delhi in terms of laying down these responsibilities is one that you worked on, which is the 8889 judgment, and it gives very, very comprehensive guidelines. But as we know, they're not really being followed. Why do you feel that they've failed? And if you were to work on that case again today, and you were to try again today to give new guidelines that you feel would be more comprehensive or more likely to achieve their goal, what sort of guidelines would you recommend? Thank you.
Right. So this judgment 8889 was initiated based on communication which Bharti Ali had with Justice Sikri based on an RTI. It was taken suo moto, and then when the process culminated, it was a consultative process. We did not take an adversarial approach, thanks to the councils representing various parties. It was because the facts were so much on the face of everybody. There was no running away from this, that in the capital city you had hundreds of minors established cases. So because of the efforts made by the bench and the councils representing different departments, a consensus judgment was drafted, and the assumption was that everybody owns up to this. It lasted for some time. The enthusiasm to implement those directions lasted for a good number of years. One of the reasons was that the matter was kept pending on the judicial side. So there were constant reports being sought, and the momentum fizzled down as soon as the matter was closed. And when the matter was closed, all of us had this sense. I remember Bharti was like, इसको बंद मत होने देना, नहीं तो कुछ होगा नहीं. राइट, हम लोगों ने कहा नहीं ठीक है, अब इतनी मोटी फाइल हो गई है, जज साहब भी कैसे पढ़ेंगे, इतना सारा कंप्लायंस आ रहा. मेजर स्टेक होल्डर थे 15. आई विल जस्ट लिस्ट आउट किनको किनको कंप्लाई करना था. स्टार्टिंग फ्रॉम कमिश्नर ऑफ पुलिस, वेरी एक्सप्लिसिट रोल, क्या करना है आपको. प्लीज रीड दैट जजमेंट ऑल्सो. कमिश्नर ऑफ पुलिस, ऑल द DCPs, all the SHOs, all the investigating officers, and the officers acting on behalf of IOs in specific cases, nodal head of special juvenile police unit, prison authorities, Tihar jail and the Rohini jail are mentioned, juvenile boards, legal service authority, government hospitals, courts, magisterial courts, legal aid lawyers, NCPCR, juvenile welfare officers, bar association, and जेल विजिटिंग लॉयर्स. ये 15 तो उसमें बिल्कुल लिस्ट हैं कि इनको करना है. द रीज़न इज इन द जजमेंट इटसेल्फ. पैरा 18 सब पैरा 2, उसमें एक पैराग्राफ है जो डिटेलिंग नहीं हुई, लेकिन आई विल जस्ट रीड दैट आउट. आई थिंक द रीज़न इज दैट वाई इज नॉट बीइंग इम्प्लीमेंटेड, एंड इट्स पार्ट ऑफ द जजमेंट. जस्ट फ्यू लाइन्स. Granting compensation to the victims in respect of wrong done has become a matter of norm, right? However, it is necessary to ensure that the compensation should not become a tool for the state to brush wrongs committed by their officers. We heard Rashmi, right? She said that आपने बोला कि आपने एज बताई थी 17 और पुलिस ऑफिसर ने जिद करके 19 लिखी. तो ये अकेले आपकी कहानी नहीं है, सब बच्चों के साथ यही होता है, राइट? तो बहुत डेलिब्रेट है ये. कमिटेड बाय देयर ऑफिसर्स अंडर द कारपेट. इट्स नेसेसरी टू होल्ड देम पर्सनली अकाउंटेबल, राइट? इसी केस में करीब 150 ऑफिसर्स को पर्सनली अकाउंटेबल ठहराया गया. उनके करियर बुक में एडवर्स एंट्री रिकॉर्ड की गई, विच डिड नॉट हैपन सेकेंड टाइम. जब 800 बच्चों का रिकॉर्ड अभी लेटेस्ट 2022 में दिल्ली हाई कोर्ट में दिया गया, तो वो जो 800 केसेस थे उसमें अकाउंटेबिलिटी फिक्स नहीं हुई. पहले राउंड में सारे ऑफिसर्स की सर्विस रिकॉर्ड ख़राब हुए, इसलिए थोड़ा सा डर था कि भाई अगर मिस्टेक करोगे तो उसको भुगतना पड़ेगा. वो अकाउंटेबिलिटी जो है वो न होना, आई विल से कि वो एक मेजर रीज़न है कि ये कंप्लाई नहीं हो पाया. हम लेटेस्ट फिगर दे देते हैं इसका कंप्लायंस लेवल समझने के लिए. और ये अपडेट है मेरे पास 9 नवंबर 2023 का. ये कोर्ट में दिया गया है कि ये इन दैट केस, हाँ इसी केस में 249 लोग जो विजिट होती है जेलों की, NCPCR और DSLSA का ज्वाइंट पैनल. लॉ में होना चाहिए कि ज्वाइंट, लेकिन वो असल में केवल NCPCR का पैनल है. 249 249 माइनर्स वर आइडेंटिफाइड बेस्ड ऑन द लास्ट विजिट विच वॉज कैरीड आउट by the NCPCR panel. Now don't ask me when was the date that this visit was carried out. डेट बहुत पीछे की है. 249 लोग आइडेंटिफाई हुए. उसमें से 30 लोगों को जो विजिटिंग पैनल है उसने रेकमेंड नहीं किया एज इंक्वायरी के लिए। तो जब वो जेल जाते हैं तो आइडेंटिफाई करते हैं कि ये लोग प्रोबेबल माइनर्स हो सकते हैं, कन्विक्ट और अंडर ट्रायल दोनों में। तो 30 लोगों को कहा कि इनका एज इंक्वायरी हम रेकमेंड नहीं करते हैं, 219 लोगों का उन्होंने रेकमेंड किया। नंबर ऑफ केसेस फॉरवर्डेड फॉर एज डिटर्मिनेशन, तो एनसीपीसीआर का पैनल फिर वो डीएसएलएसए को फॉरवर्ड करता है कि ये 219 लोग हैं जो हम रेकमेंड कर रहे हैं कि आप इनका एज इंक्वायरी कराइए। तो फिर डीएसएलएसए के थ्रू वो प्रोसेस आगे बढ़ता है। 219 में से 176 मैटर्स में एज इंक्वायरी कंडक्ट हुई, 176 केसेस में कंडक्ट हुई, और उसमें से आफ्टर द कोर्ट्स कंडक्टेड द एज डिटर्मिनेशन अंडर सेक्शन 9, 146 वो डिक्लेयर्ड एडल्ट्स, 146 वो डिक्लेयर्ड एडल्ट्स, 30 वो डिक्लेयर्ड माइनर। 30 ये बहुत बड़ा नंबर है, राइट। इसमें से कुछ केस हैं जो प्रोसेस नहीं हो पाए, उसके रीज़न हैं 14 बच्चों के जो एंट्री हुए वो रॉन्ग पर्टिकुलर्स लिख करके आए थे, 10 बच्चे ऐसे थे जो रिपीटेड थे, जो पहले भी रेकमेंड हो चुके हैं, उनको दोबारा से रेकमेंड किया गया, 10 ऐसे थे जो या तो अंडरगॉन थे, रिलीज थे, डिस्चार्ज थे, या उनके क्लेम को विड्रॉ कर लिया गया किसी स्टेज पे, और 2 का रीज़न लिखा हुआ है प्राइवेट काउंसिल थे। ये है स्टेटस ऑफ कंप्लायंस सो फार। इसका एक दूसरा पार्ट भी है जिसमें बर्थ रजिस्ट्रेशन को लिंक करने की बात है, उसको दिल्ली गवर्नमेंट ने बहुत सीरियसली कंप्लाई किया और एक गजट नोटिफिकेशन निकाला, और जिसमें डिजिग्नेट किया जेजेबी के प्रिंसिपल मैजिस्ट्रेट और सीडब्ल्यूसी के चेयरपर्सन को एज ए रजिस्ट्रार ऑफ डेथ एंड बर्थ। तो आई एम टोल्ड कि उस प्रोविज़न का भी यूज़ मिनिमल हुआ है, कुछ केसेस में बच्चों के बर्थ वगैरह रजिस्टर हुए हैं, ताकि दोबारा से कभी उनकी एज नहीं, उनका एज का कोई प्रूफ नहीं है, ये सवाल ना उठे। और तीसरा एक कंपोनेंट है जो हमने देखा है, जेजेबीज के जो एज डिक्लेरेशन के ऑर्डर होते हैं, आप देखिएगा उसमें एक लाइन लिखी होती है, कॉपी ऑफ दिस एज ऑर्डर बी सबमिटेड टू एसजीपीयू। वो क्यों लिखी होती है कोई जानता नहीं है, वो एसजीपीयू को इसलिए भेजी जाती है 8889 के कंप्लायंस में कि आप वो ले जाइए और अपना डेटा मेंटेन करिए, ताकि आईओ दोबारा कभी अगर इन्वेस्टिगेशन करें तो उन बच्चों का एज का डेटा आपके पास रहे। लेकिन वो एसजीपीयू को कॉपी जाती ज़रूर है, लेकिन एसजीपीयू को पता नहीं कि उनको उन ऑर्डर्स का करना क्या है, राइट। तो बहुत सारा लैक ऑफ कम्युनिकेशन भी है इंटर डिपार्टमेंटल। आई थिंक आई विल स्टॉप हियर।
सो अगर हम एक स्टेप पीछे लेंगे एंड वी स्टार्ट द जर्नी द सेम वे द एवरेज चाइल्ड स्टार्ट्स द जर्नी, उनका फर्स्ट एक्सपीरियंस जस्टिस सिस्टम के साथ, पुलिस के साथ होता है। सबसे पहला इंटरेक्शन उनका होता है अरेस्टिंग ऑफिसर के साथ, इन्वेस्टिगेटिंग ऑफिसर के साथ। इस समय द रूल ज़्यादातर इज मेंट टू बी एन एज इंक्वायरी एंड द एज ऑफ द चाइल्ड इज मेंट टू बी लिस्टेड ऑन द अरेस्टिंग मेमो, बट दैट्स नॉट हैपनिंग। अभी एक रिपोर्ट लॉन्च हुआ है प्रोजेक्ट 39A का, जिसमें कहा गया कि the arrest memo draft that is used in Delhi does not have any reference to the age of the accused. So it's fundamentally not taking place. हमने रश्मि की भी कहानी सुनी है, अगर ऑप्शन भी होता तो चांसेस है कि गलत लिखा जाता। सो मिस्टर कांत, मैं आपसे पूछना चाहूँगी, इस इशू में हम सब सुन रहे हैं कि फंडामेंटल बायसेस है पुलिस के, फंडामेंटल डिज़ायर है कि जिस तरह सिस्टम चल रहा है वैसे ही चलना चाहिए। हम लोग बात करते रहते कि पुलिस सेंसिटिविटी ट्रेनिंग्स होनी चाहिए, पुलिस का अकाउंटेबिलिटी होना चाहिए, लेकिन मैं आपसे समझना चाह रही हूँ, इज़ दिस अ रीजनेबल अटेम्प्ट? डू यू थिंक दैट गिवन दैट देयर आर सम fundamental human biases at play here and it is such an entrenched issue that has lasted for so many years, do you see a possibility of solving this issue somehow, or do you think it's more likely and more realistic that we focus on working around the police rather than working with the police when we try to address this issue?
First of all, let me expand my horizon, because I come here less because of police and more because of the fact that I happen to be the founder of Prayas. I happen to be the first chairman of Child Rights Commission. 34 years in police and now 36 years with you guys, working with you. So my experience is very different. Now coming back to the points which Anant has spoken about, it's very clear that the roles are well defined today. But I go back to Juvenile Justice Act 2000. I hope you know that Sheila Barse, whom I used to call Sheila Didi, myself, Sheila Didi, and Professor Bibi Pandey, we were three in the drafting committee of JJ Act, officially. And then the kind of law that it was created into, it makes everything very, very clear. 2000 Act is a radical departure from 1986 and the law of 1960 Children's Act. And probably nothing is left to be told, because not only the role of police, the role of all stakeholders are very clear. But decidedly, I would not like to be devil's advocate here. I would not like to say that the police role is less or the primary role is that of police. There is no doubt about it. I think when Gitanjali talked about the police experience, sad enough, I think that could be quite a common experience across the country. And Rashmi, of course, also talked about the same thing. I am fully aware that it happens. Now, nearly 220,000 children in need of care and protection, children in conflict with law, they were brought into Prayas. I hope you know that in past 26 years. 21,000 happened to be the juveniles who were in Firoz Shah Kotla observation home, which was run by Prayas for 26 years. Exactly 21,000, let me inform you. And I met them very regularly because that was my area of interest. And at one stage when I was DCPCR chairman, my interest and my liability became very different. In fact, Justice Deepak Mishra, Chief Justice, Delhi High Court, Justice Madan Lokur, all of them used to participate and come here. And the children freely told all about what was happening to them. Not more than 30% of children who came to Firoz Shah Kotla, in my opinion, were actually the correct kind of children being brought to justice or brought to JJ system even. That was the position. 70%, 60% happened to be almost innocent. That's one part. But coming back to this entire issue, the elder children and police giving them a wrong kind of age, it's very, very rampant across the country. There is no doubt about it. But then there are many other stakeholders, including DCPCR, NCPCR, including Juvenile Justice Board, including voluntary organizations who have access to jails, access to police setup, and who are supposed to look after children. And of course, the legal service authorities. I think all of us have equal role to play in the sense that all these organizations have equal legal responsibility in the matter. And the child's age determination of child is, it may be JJB's function, but I would not like to accept that JJP alone is supposed to do it. The function starts with police, number one. Secondly, all those who, I am surprised how Rashmi was not defended by anybody, how Rashmi never met anybody from a family and all. I have no idea why it happened. I have no idea. Otherwise, we are, 3.2 million voluntary organizations in the country, the largest chunk being the children's organizations, all of us being part of it. I think we have a role to play in this area. And then the age to be decided and age to be declared, age to be claimed, they have to be done within JJ system, isn't it? If a child, see, broadly speaking in the country, as you know, nearly 40 to 45,000 children are being apprehended and nearly 40,000 cases take place. It's minuscule compared to the number of CNCP, who must be 95-97% of the entire JJ system. CCL are a very small number. And the number is small for the reason that, as you know, in JJ Act, there is no need for FIR. So only those who commit a crime and this punishment is more than 7 years, heinous offences, that FIR is required to be registered. So broadly speaking, if you look at that, there are large number of cases where children have committed crimes and they have been found to be doing so. But if they alone are brought by the police, or let's say come to the police station and brought within the fold of police, FIR is not being registered, they are not being recorded. Where they go, there is no idea about it. But then it's a fact that the small number, that is 45,000 of them, in respect of whom FIRs are being registered, in respect of whom the entire process of JJ system goes through various steps. I'm really surprised that how so many of them, you are not able to find more than 9,000 of them, so many of them remain in the jail and there's no way they get out of it. People like Sunil, for example, who is an activist and being an ex-jail law officer, he understands better. But since I had also opportunities to investigate many cases concerning jails, including Charles Sobraj's case, so I am fully aware that there are umpteen opportunities in the jail. umpteen opportunities with the voluntary organizations dealing with the cases, endless opportunities with the police and juvenile justice board to really find out that the particular person being brought in the system is a child. I mean, it's something unthinkable why it is not happening, and I can only compliment you that you have started the process. It should be brought to logical conclusion. I don't think any child in the country, across the country, should remain there. In fact, not only this thing that the child goes to jail, let me inform you, 1988, when I was Deputy Commissioner of Police Crime in Delhi, that violent decade of India, about which I have dealt with separately. See, when I found that nearly 15-20 children were locked up in New Delhi railway station, in the lockup of police lockup, and that was one of the reasons why I got into this entire activity of creating an organization or doing all these things. It has been there, it has always been there. That police lockup also, let me inform you, why exclude lockups? I mean, many children, they really are in the lockups. In fact, when I was DG Police of Arunachal Pradesh, one of the activists of Northeast, when he informed me that in a police station called Daparijo, that's a district in Arunachal Pradesh, there were 5 children in a lockup. And they were in the lockup for the reason that these children were being attacked on account of some inter-tribe conflict, where some lady had run away with somebody and somebody was killed and all that. So they were kept in protection. So the police mindset, I am saying, the police mindset is being governed by a variety of things, and decidedly it has to change, because they are the starting point. You are absolutely correct. And as a starting point, I think it is their job, decidedly it is their job. And now that we have got special juvenile police units, we have got child welfare officers, we have got juvenile welfare officers, and then across the country, most of the officers have been oriented towards their job and their role and their kind of obligations within JJ Act. I find no reason why the police should fail so much. But let us not limit it to police or to JJB. It's multi-sectoral requirement which I think we should adhere to. Okay?
Absolutely, sir. Thank you for that. I agree with you. It's ultimately every stakeholder working together in the space. The reason I started with the police is because that's very frequent. Well, that is always the first point of interaction with the child, and very frequently the first point at which they face violence of any nature. And if it could be stopped at that point, then they wouldn't have to spend even a single day in jail. At the end of the day, many stakeholders...
No, they have the primary role to play, the most important role to play. So but then we cannot limit to police and JJB. JJB, of course, since we talk about, in your report, you are really talking about JJB a lot. I think there are other agencies in the process who are equally responsible.
I hope that during this conversation we can speak about some of the other stakeholders responsible. The report, of course, is limited to an RTI study on 2 particular points, but I'm hoping that in the course of this conversation we can discuss the role of a few other entities as well. So on that note, the next point at which the child interacts with the justice system is when they're produced before a magistrate. And very often the hope is that at that point, even if the police didn't identify that this is a child, the magistrate will be able to refer the child to the juvenile justice system and divert them back to where they should be. Anant, you've been a lawyer in this space for many, many years. You've worked with children who have faced that step and have yet not been diverted back to the juvenile justice system. So in your opinion, what can be done to improve things at this stage?
Sorry, I didn't get the question.
Sure. I'm saying there are times when a child is visibly looking like a child. We've had children who...
On the face of it. That's correct. Which is also a part of law.
Absolutely.
If a child, in the very appearance, if the child it appears to be a child, the Child Welfare Committee and Juvenile Justice Board, both of them can err on the right side. Exactly. They have a legal right to err on the right side. They can declare a child, let's say a child is 16 or 17 years, like, Rashmi was. And then in that situation, the Child Welfare Committee or JJB declares the child to be a child, and the child turns out to be adult. Yes. They are not really committing a blunder.
Absolutely. But I'm saying before we get to the point of the JJB, when the child is first produced before a magistrate, there are children who visibly look like children, there are children who say, okay, I am a child, there are children who can do neither of these things, but there's supposed to be some sort of application of...
I get it. So recently I went to a children court, which is supposed to be a super JJB, ultra sensitive. The judge even didn't look at the person. Judge was sitting in the chamber, the warrant went inside, and I was there like, kya hua? Sir, ho gaya sign, right? तो अगर, एंड आई सॉ इट जस्ट हैपन हियर लाइक फ्यू डेज अगो, अगर कोई माइनर प्रोड्यूस भी हो रहा है और अगर जज इतनी भी बॉदर नहीं कर रहे हैं कि कम से कम एक्यूज को देख लें, तो अगर भी वो 12 साल का है तो हु इज़ गोइंग टू, और हमको याद है इस केस में उस बच्चे की माँ भी आई थी, राइट, एंड दे कम विद होप कि कोर्ट में जाएंगे तो कोई कम से कम उनको नोटिस करेगा।
एज ए विक्टिम ऑफ क्राइम और ए विटनेस में भी
नहीं, न विटनेस न विक्टिम, ये अक्यूज का हम बता रहे हैं कहानी।
चिल्ड्रंस कोर्ट में। अच्छा, दैट्स आई गेट इट।
आई बिलीव दैट फर्स्टली जो पहले दिन का प्रोडक्शन है वो दैट हैज़ टू बी अ मीनिंगफुल प्रोसेस, जहाँ कम से कम जजेस के पास अपॉर्चुनिटी हो देखने का कि मेरे सामने अपीयर कौन हो रहा है। आई वॉज इन दैट कोर्ट फॉर सम टाइम, और जो पुलिस लोगों को लाद रही थी, ले जा रही थी, उसमें बहुत सारे लोग हम देख रहे थे कि वो विजुअली माइनर्स दिख रहे हैं, क्योंकि उनको देख करके लगता है कि वो बस छोटे छोटे बाल अभी आना शुरू हुए हैं, वो मुश्किल से 17-18 साल के ही होंगे। एंड आई वॉज वंडरिंग कि अगर इन कोर्टों में कोई जज देख ही नहीं रहा है तो इनके लिए बोलेगा कौन। सो आई थिंक रोल very proactive role. I don't think it's even proactive to expect a judge to even look at the accused. ये bare minimum है कि अगर कोर्ट में आप प्रोड्यूस कर रहे हैं तो कम से कम उसको देखिए कौन है वहाँ पे, एंड आस्क क्वेश्चंस। गोपीनाथ घोष पुराना 1983 का जजमेंट है जिसमें सुप्रीम कोर्ट ने ये कहा था कि ऐसा क्यों हो रहा है कि केसेस मेरे पास तक आ रहे हैं, ये नीचे मजिस्ट्रेट की कोर्टों में हो क्या रहा है। और उस वक्त उन्होंने कहा था कि कोई भी 21 साल की एज तक का एक्यूज्ड होगा, इट विल बी रिस्पॉन्सिबिलिटी ऑफ द मैजिस्ट्रेट टू सेटिस्फाई टू हिमसेल्फ दैट द पर्सन प्रोड्यूस बिफोर मी इज़ नॉट अ माइनर। ये होता नहीं है, इक्के दुक्के केसेस हम लोग साइड कर सकते हैं कि हाँ 2-3 केसेस हुए, लेकिन बाय एंड लार्ज एज अ प्रैक्टिस दिस हैज़ नॉट इस्टेब्लिश्ड कि जहाँ आप एज के और एक बहुत बड़ा रीज़न हमको लगता है इमोशनल लेवल पे क्राइम करने वालों के साथ जुड़ा हुआ स्टिग्मा है कि हम अपना टाइम, अपनी एनर्जी और अपना कंपैशन इन लोगों पर क्यों खर्च करें जो सोसाइटी के मतलब क्रिमिनल्स हैं बेसिकली। वाई आई शो, अदरवाइज जिनके लिए कंपैशन है लोग पूरा टाइम देते हैं। तो जुवेनाइल्स के लिए जो बायस है, जो स्टिग्मा है, वो एक मेजर रोल प्ले करता है कि लोग अपनी पावर्स को भी यूज़ इस सेक्शन के लिए क्यों नहीं करना चाहते। अब उसमें आप इंक्लूड कर सकते हैं पुलिस को। जब सर बता रहे थे तो हम सोच रहे थे कि आई नो सो मेनी पुलिस ऑफिशियल्स हु आर अदरवाइज वेरी फाइन पीपल, तो वो ऐसा क्या उनके दिमाग में आता होगा कि जब वो किसी बच्चे का केस इन्वेस्टिगेट कर रहे हैं तो 17 की जगह 19।
नहीं, ये तो स्टैंडर्ड है। वो सोचते हैं कि पहले डिक्लेयर 18 कर दो किस तरीके से, अगर उस कस्प पे हो दैट पॉइंट, तो ये तो आई एग्री कि ये तो
जुवेनाइल जस्टिस सिस्टम में हमने एक और चीज़ देखी है कि बहुत सारे पुलिस ऑफिसर्स को जुवेनाइल जस्टिस सिस्टम मुसीबत लगता है। उनको लगता है क्या मुसीबत है ये, वहाँ जाओ ये 50 तरह के अजीब गरीब कागज़ मांगेंगे, हाँ, और वहाँ 3-3 लोग बैठे होंगे, यहाँ तो कोर्ट में एक जज होता है, जज यहाँ देखेगा।
Can I make a small point here? See, I hope everybody appreciates. The police is not supposed to conduct any investigation because there is no system of any trial or conviction, anything in JJ system. The police is supposed only to find the antecedents and circumstances of a child being apprehended, isn't it? That's the law. JJ Act very clearly provides. So obviously तुम ठीक कह रहे हो कि when the police role is limited to that, in that case they are not collecting evidence, which is their normal way of functioning. They collect evidence, they marshal evidence, they give it to prosecutor, it goes to the court. Those things police is not supposed to do under the law. So this different kind of process altogether, that becomes, that creates the problem as you are saying, because it doesn't gel with the police mindset, the police system, the police process, which I always say it's totally outdated. It remains colonial despite these laws coming through. So obviously ये सही है कि this JJ system is something which is antithesis of what the police happens to be. This point I would like to clarify as an ex-policeman. Okay.
तो वो एक अवर्जन रहता है, जुवेनाइल जस्टिस सिस्टम इज सीन एज ए प्रॉब्लम। अब दिल्ली में तो खैर वो नहीं होना चाहिए, लेकिन कई जगहों पर आई कैन ऑल्सो अंडरस्टैंड कि लॉयर्स के लिए, खास तौर से हमने लीगल एड के लॉयर्स को हमने सुना है बात करते हुए, वो बोलते हैं कि वो 400 रुपये 500 रुपये का हमको पेमेंट मिलता है, वो भी बड़ी मेहनत के बाद मिलता है, मिलेगा नहीं मिलेगा उसकी भी गारंटी नहीं है, और हमको जाना पड़ेगा 30 किलोमीटर दूर जहाँ ना बस जाती है ना ऑटो जाती है लीगल एड देने के लिए, क्योंकि जुवेनाइल होम्स वो शहर के बाहर बसें होते हैं वहाँ, और वहीं पर जजें भी बैठती है, तो हम कैसे अपना कोर्ट कॉम्प्लेक्स छोड़ करके वहाँ जाएं? दैट एक्सप्लेन्स कि जो लीगल एड लॉयर्स अपॉइंटेड भी हैं वो क्यों उन बच्चों के लिए अपीयर नहीं हो पा रहे हैं। वो बहुत प्रैक्टिकल रीजंस हैं फॉर एवरीबडी, बट आई थिंक एट द कोर ऑफ इट इज़ दैट देयर इज़ नो कंपैशन फॉर दिस सेक्शन ऑफ सोसाइटी। ये जो बच्चे हैं इनके लिए किसी को चिंता है नहीं, वही ऑपरेट करता है हर जगह पर। दैट आई विल से वो रूट क्या है, क्योंकि आई हैव सीन पीपल जिन्होंने काम किया है उनके दिल में पहले तो कंपैशन जगा है कि ये बच्चे असल में दे वर्थ, और फिर वो काम शुरू होता है, फिर चाहे वो पुलिस ऑफिसर हो चाहे वो जज हो। आई हैव सीन जुडिशियल ऑफिसर्स चेंजिंग कम्प्लीटली देयर माइंडसेट बिकॉज उनका कंपैशन जाग गया किसी बच्चे के लिए।
Thank you, Anand. The next point at which the child interacts with the justice system after both the police and the magistrate is the jail. In the jail, the Delhi prison rules direct that the jail superintendent should identify if a child is a juvenile. The model prison guidelines state that the chief medical officer should also try to identify if a child is a child, and then not allow the incarceration in prison to take place. So there are steps that are meant to be in place. But असलियत में हमने सुना है बहुत बार कि there are children where everybody knows this is a child. It's open knowledge within the prison, but the child continues to remain in the prison. Mr. Gupta, you worked with Tihar for such a long time. आप मुझे बताइए, in your opinion, who should be the point of responsibility? Can there be one point of responsibility within the prison for ensuring that a child is not remaining incarcerated there, and how can that accountability be ensured?
चलिए मैं आपको हिंदी में जो बात करता हूँ
सर,
तिहाड़ जेल में मेरी एंट्री जो है 1981 में हुई थी। उस टाइम सर वहाँ पे डीसीपी वेस्ट था। तो 81 में जब मेरी एंट्री हुई थी तो उस टाइम पे कोई बच्चे वगैरह की तो कोई कंसेप्ट थी नहीं, नोबडी वाज अवेयर अबाउट द चाइल्ड राइट। और मैं तो अनंत अस्थाना को कहता हूँ कि उन्होंने इतनी अवेयरनेस क्रिएट की है कि अब हमें भी पता लगने लगा है कि चाइल्ड राइट कोई चीज़ होती है। उस टाइम पे 81 की बात कर रहा हूँ, अंग्रेज़ों को ये पता था कि जो यंग प्रिजनर हैं उनको एडल्ट प्रिजनर से अलग रखना है। ब्रिटिशर टाइम्स का 1894 का हमारा जो पंजाब जेल मैनुअल था वो ये कहता था कि आप यंग प्रिजनर को एडल्ट प्रिजनर से अलग रखेंगे। 1894 से वाली बात चली आ रही थी, पर कोई इसकी अवेयरनेस नहीं थी। अब हमारे यहाँ एडोलेसेंट वार्ड होते हैं जिसमें 18 से 21 साल तक के बच्चे आप रखते हैं, पर जनरली उसमें मैं 88 से पहले की बात कर रहा हूँ, जो भी 18 से 21 साल तक के बच्चे होते थे, मुझे लगता है आधे से ज़्यादा तो बच्चे 18 साल से नीचे के ही होते थे, 16 साल 15 साल 14 साल। और उस टाइम पे कोई लॉ ऐसा कुछ एनफोर्स होता नहीं था। ये तो थैंक्स टू जुवेनाइल जस्टिस एक्ट 86 आया, उसके बाद हमें पता लगा कि जुवेनाइल्स के बारे में गवर्नमेंट इतना सोच रही है तो हमें भी सोचना चाहिए। तो लकली मैं जेल ड्राफ्टिंग कमेटी थी, जेल मैनुअल ड्राफ्टिंग कमेटी थी, मैं उसका आई वाज द मेंबर ऑफ दैट कमेटी। तो मुझे जुवेनाइल नाम जो है बड़ा अच्छा लग रहा था। पहले चाइल्ड वगैरह होता था तो जुवेनाइल बड़ा अट्रैक्टिव सा वर्ड लग रहा था। तो मैंने उसमें एक चीज़ डाली कि इट इज़ द पर्सनल रिस्पॉन्सिबिलिटी ऑफ द सुपरिटेंडेंट जेल टू आइडेंटिफाई दैट नो जुवेनाइल इज एडमिटेड टू द जेल। 86 में जुवेनाइल जस्टिस एक्ट आया, 1988 में जो है हमारा प्रिजन एक्ट बना, तो उसमें हमने ये चीज़ डाल दी कि ये कोई जुवेनाइल जेल में नहीं होगा। तो उसके बाद से सुप्रीम जेल ने देखना शुरू किया कि कोई भी जुवेनाइल जो है जेल में ना आए। तो फिर भी जो है पर इतना ज़्यादा उसकी जो है जो कोई इंश्योर नहीं कर रहा था कि बच्चे जेल में हैं या नहीं है। रियल जो चीज़ शुरू हुई है 88 से जस्ट पहले, जब 1986 में जुवेनाइल जस्टिस एक्ट आया है, एक पेटिशन लगी थी सुप्रीम कोर्ट में, दैट वाज फाइल्ड बाय संजय सूरी, ही वाज इंडियन एक्सप्रेस जर्नलिस्ट। he filed the petition before the Supreme Court stating that juveniles are being sexually exploited in the jails. जब उन्होंने ये वाली बात कही तो हमें भी नहीं पता था. आई वॉज दी एडमिनिस्ट्रेटर ऑफ द जेल, आई वॉज सुप्रिटेंडेंट जेल. मुझे नहीं पता था कि बच्चे जो है दे आर बीइंग एक्सप्लॉइटेड इन द जेल. जब उन्होंने ये वाली बात कही तो उसके बाद सुप्रीम कोर्ट ने डिस्ट्रिक्ट जज को जो है तिहाड़ पे भेजा. डिस्ट्रिक्ट जज साहब ने अपनी रिपोर्ट दी. दैट वाज क्वाइट रिवीलिंग. उसमें था कि जो जितने इन्फ्लुएंशियल प्रिजनर होते हैं, जो हार्डन क्रिमिनल होते हैं, these juveniles are doing service for them. और इसके लिए पैसे लिए जाते हैं. जो जेल के जो हमारा स्टाफ होता है, दे आर चार्जिंग मनी फॉर सप्लाइंग दीज चिल्ड्रन टू दी इन्फ्लुएंशियल प्रिजनर. तो इतनी रिवीलिंग ये रिपोर्ट थी. उसके बाद से पहली बार सुप्रीम कोर्ट ने उसमें काफ़ी सीरियस व्यू लिया. उससे पहले जो भी प्रिजनर जेल में आते थे उनकी एज नहीं लिखी जाती थी उनके वारंट के ऊपर. बिफोर दैट उनके नेम, फादर नेम, थाना, FIR नंबर वगैरह ये लिखा, एड्रेस लिखा होता था, बट एज वाज नॉट बीइंग मेंशन इन दी वारंट. जब सुप्रीम कोर्ट ने हमसे पूछा तो हमने उनको कहा कि क्योंकि एज नहीं लिखी होती तो इसी वजह से बहुत सारे बच्चे जो है जेल में आ जाते हैं. तो उन्होंने फिर डायरेक्शन 86 में की कि जो भी प्रिजनर जेल में आएगा उसकी एज जो है लिखी जाएगी. इवन दो उससे एक चीज़ आसान हो गई कि जो कोई बच्चा जो है बहुत सारे बच्चे जेल में आने से रुक गए. उसके बाद क्या हुआ कि ये होता रहा, बच्चे चलते रहे. बेसिकली नोबॉडी वाज सीरियस. देखिए हमारे दिल्ली में क्या होता है, मैं हिंदुस्तान का तो नहीं कहूँगा, दिल्ली का बताऊँगा कि दिल्ली में जब तक आपका कोर्ट का डंडा नहीं होता या कोई पनिशमेंट एक्शन नहीं होता, कुछ काम नहीं करता. जब ये सब कुछ जब ये हुआ, एक जब प्रोविजन उसमें डाला जेल मैनुअल में कि जो जेल सुप्रिटेंडेंट जो है पर्सनली रिस्पॉन्सिबल होगा अगर कोई भी जुवेनाइल मिलता है, उसके बाद से धीरे धीरे ये चीज़ कम होनी शुरू हुई. जो सेशन जज जो जेल में विजिट करते हैं, it is their primary duty when they are visiting the jail, it is their primary duty to see, this is the first point in their duties of as a visitor, that no juvenile is lodged in the jail. सेशन जज विजिट करते हैं, बहुत अच्छे तरीके से विजिट करते हैं, पर फिर भी क्या होता है, वो जेल सुप्रिटेंडेंट से पूछा हम भी कोई जुवेनाइल तो नहीं है आपकी जेल में, तो जेल सुप्रिटेंडेंट अपनी रिपोर्ट दे देते हैं, नहीं कोई जुवेनाइल जेल में नहीं है, तो उसको एज इट इज़ गॉस्पेल ट्रुथ उसको मान के वो उसको लिख देते हैं. तो इसमें जब तक आप कोई रिस्पॉन्सिबिलिटी किसी की फिक्स नहीं करते कि इसकी रिस्पॉन्सिबिलिटी होगी कोई भी जुवेनाइल अगर मिलता है, तब तक मुझे लगता है कि इसमें इतना कुछ ज़्यादा जो है हो नहीं पाएगा.
वो एज जो आप कह रहे थे, वो एज पहले से रिकॉर्डेड आता है ना?
हाँ, एज जो है
वो तो कोर्ट प्रोसेस में ही एज आ गया.
86 में होना चाहिए.
नहीं, आप जेल मैनुअल की बात कह रहे थे.
हाँ, जेल मैनुअल में जैसे एज रिकॉर्डेड आता है, उसके बाद क्या होता है कि हर एक का मेडिकल एग्जामिनेशन होता है. जब मेडिकल एग्जामिनेशन होता है तो डॉक्टर जो उसका पहले दिन ही आते सार उसका मेडिकल एग्जामिनेशन होता है. अगर डॉक्टर को लगता है कि ये 18 साल से कम है तो डॉक्टर वो लिख देगा ये वाली बात और उसको रेफ़र कर देगा दीनदयाल उपाध्याय हॉस्पिटल, जो यहाँ का है, तिहाड़ का मैं बता रहा हूँ.
एज डिटर्मिनेशन
टेस्ट के लिए दैट टेक यूजुअली 7 day टाइम. तब तक आवर जेल मैनुअल से कि आप उस बच्चे को और लोगों से अलग रखेंगे. कई बार तो मुझे लगता है कि सोलिटरी कन्फाइनमेंट हो जाती है, जो कि नहीं होनी चाहिए, तो हम बच्चे को अलग रख देते हैं, दूसरे लोग अलग होते हैं, और 7 दिन 15-10 दिन जो है उसमें जब उसकी रिपोर्ट आ जाती है उसको हम पेश करते हैं कंसर्न कोर्ट के आगे, और वो उसके ऑर्डर करते हैं कि इसको चिल्ड्रन होम जो है भेजा जाए.
सर, आपकी एक्सपीरियंस में ये प्रैक्टिकली हो रहा है? CMOs आइडेंटिफाई कर रहे हैं एंड सुपरिटेंडेंट्स जिम्मेदारी ले रहे हैं, या आपके एक्सपीरियंस में इतना नहीं हो रहा है इस समय?
नहीं, ये हो रहा है. देखें क्या होता है कि जेल की जो फंक्शनिंग है वो ऐसी है कि जो जेल रिफॉर्म्स की हम बात करते हैं, जेल रिफॉर्म्स तभी शुरू होती है जब कोई ट्रेजेडी हो जाती है। शुरुआत का पॉइंट ही वो होता है जब कोई ट्रेजेडी हो जाती है। पहले जेल में क्या होता था कि ज़्यादा
आपकी सारी मैनुअल वगैरह मेरे केस के बाद आई थी, चार्ल्स सुबराज केस के बाद ये मैनुअल बनी थी आपकी।
तो क्या होता था, पहले क्या होता था कि जेल मैनुअल कहता था कि जो 1894 का था कि जो भी प्रिजनर जेल में आएगा तो एज सुन एज पॉसिबल ही विल बी मेडिकली एग्जामिन्ड बाय द मेडिकल ऑफिसर और मेडिकल सबऑर्डिनेट। उसके बाद क्या होता है, ये चलता रहा। 93 में मैडम किरण बेदी आई जेल में, तो एट दैट टाइम एनजीओ ने रिपोर्ट दी थी, उसमें था कि जो सोडोमी की घटनाएं हैं ये बच्चों के वार्ड में बहुत ज़्यादा हो रही हैं। जो एनजीओ की रिपोर्ट थी उसमें था कि 80% बच्चे जो है जो इसमें एडोलसेंट वार्ड में है उसमें सोडोमी होती है बाय फोर्स या दे आर विलिंग पार्टनर, ताकि पुलिस रिपोर्ट वगैरह उसमें जो कोई होती नहीं। तो उस टाइम पे हमने ना सोचा कि क्या किया जाए, इसको क्या करें। तो हमने फिर एक आइडिया आया कि कंडोम रख देते हैं। हम लोगों ने वी स्टार्टेड पुटिंग द कंडोम इन द एडोलसेंट वार्ड। जैसे ही हमने ये शुरू किया, इनिशिएटिव लिया, उसके खिलाफ पब्लिक इंटरेस्ट लिटिगेशन लग गया दिल्ली हाई कोर्ट में। उन्होंने कहा कि नहीं, ये कंडोम रखे, वी आर एनकरेजिंग द चिल्ड्रन टू हैव सोडोमी। तो फिर वो वाला हमें अपना जो है वो उसको वापस लेना पड़ा। उसके बाद राजन पिल्लई की जो है डेथ होती है 1995 में। जो मैं बता रहा था कि जब ट्रेजेडी होती है उसके बाद ही कुछ रिफॉर्म शुरू होते हैं। उससे पहले 12 या 13 डॉक्टर हमारे पास टोटल जेल में होते थे। 24 आवर्स जो है वहाँ 24 आवर कैटर करते थे। उसके बाद एकदम जस्टिस लीला सेठ कमीशन बैठा, उन्होंने कहा कि आपकी क्या रिक्वायरमेंट है। तो हमने बताया कि डॉक्टर हमें इतने चाहिए। हमने 100 के करीब डॉक्टर मांगे थे। उस टाइम पे 120 डॉक्टर हमें जो मिल गए। जब डॉक्टर मिल गए उसके बाद हमने फिर प्रिजन मैनुअल अपना चेंज किया। उसमें ये लिख दिया, जहाँ पहले था मेडिकल सबऑर्डिनेट जो है मेडिकल एग्जामिन करेगा, उसको हमने चेंज करके कर दिया कि डॉक्टर एग्जामिन करेगा। अब जैसे ही जैसे किसी का एडमिशन होता है तो उसी दिन, क्योंकि राजन पिल्लई की जो डेथ हुई थी उसके पीछे एक रीज़न ये था कि जब वो जेल में आया था उसको 2-3 दिन तक जो है वो मेडिकल एग्जामिनेशन हुआ नहीं था, क्योंकि वो कोर्ट वगैरह जाता रहा, तो मेडिकल एग्जामिनेशन नहीं हुआ था। उस चीज़ को प्लग करने के लिए आफ्टर राजन पिल्लई डेथ इन्होंने ये कंपलसरी कर दिया कि डॉक्टर जो है जैसे किसी प्रिजनर का एडमिशन होता है उसका मेडिकल एग्जामिनेशन करेगा, ताकि पहले दिन से ही जो है उसको दवाई वगैरह कोई देनी है या जो भी और उसका वो ट्रीटमेंट करनी है वो शुरू हो जाए। और उसमें ये डॉक्टर की ड्यूटी लगाई गई कि अगर कोई भी प्रिजनर उसको लगता है कि वो 18 साल से कम है, जुवेनाइल है, तो वो उसका जो है उसको रिपोर्ट करेगा। सुपरिटेंडेंट जेल फ़ौरन उसका जो है उसका डिटेल मेडिकल एग्जामिनेशन करवाएगा और जल्दी से जल्दी उसको जो है चिल्ड्रन होम में जो है भेजा जाएगा।
ओके, थैंक यू। सो इस स्टेज के बाद अब बच्चा जेल में पहुंच गया है। अब बच्चे को आइडेंटिफाई करने के लिए there are a number of different inspections, statutory inspections, inspections directed by different court judgments that take place. The one that we looked at in the report is the visits by the JJB members, principal magistrates, to identify if there are children who are in the prison. The data that we have for this period of 6 years indicates that reports are very often in some states not happening at all. In Delhi, for instance, none at all. A number of other states where either very, very few or really no inspections of this nature are being carried out. My concern here is that there are a number of stakeholders on whom this responsibility is placed. There's some amount of multiplicity of responsibilities and overlap of responsibilities. There's also a tendency to place a lot of responsibilities on stakeholders who have other core areas of their work. I'm trying to understand if the fact that there are no or very few inspections happening in many states, do you think that's down to the JJB magistrates, Mr. Verma, not being able to do this because the core area of their work is perhaps not this, or something that they are fully occupied with? Or is there any other reason that these inspections are not taking place? And in your opinion, what can be done to address the need for having an adequate number of visits to jails so that children can be identified?
Good afternoon, everyone. Thank you, iProbono, for inviting me here. And I also take this opportunity to express my deep debt of gratitude to Honorable Sir Justice Ravindra Bhat, because under his chairmanship, the Juvenile Justice Committee of Delhi High Court has made huge strides and has contributed a lot to the development of children and rehabilitation, which probably is not publicized or not known to most of us. Now, as far as your question is concerned, the figures of Delhi, yes, they reflect that the figures are abysmally low. But when we speak to the principal magistrates, in fact, yesterday there was a session at the Delhi Judicial Academy, and when we spoke to the magistrates, some of them have actually visited the adult jails, although not as much as probably the legislature demands. But so you may need to check the accuracy of. I know you've put in painstaking effort, Mr. Krishna, and I'm not doubting that. But sometimes statistics may not reveal the correct picture. Having said that, some part of your data pertains to an era when there were only 2 or 3 juvenile justice boards, and that time also there were 16 jails, 9 in Tihar, 1 in Rohini, and 6 in Mandoli. So it would be very difficult to go on a monthly or a bi-monthly visit for the JJBs in all these 16 jails, considering the fact that there were only 2 or 3. And also, I was in JJB 3 and JJB 1 also. So when I was in JJB 1, the number of cases that I had to deal with, there were 1600 cases pending in my board. And every month, 100 fresh new cases were marked. So with this colossal, burden, perhaps the visits were lesser in number. And also, I would like to elaborate on the role of the JJB, since you've asked what does the JJB actually do apart from conducting inquiries. We also are mandated to inspect the child care institutions. So as you're aware, there are a number of child care institutions. There is the Observation Home 1, 2, Prayas, so we make visits there. There, if you'll get the data, you will find a number of visits of the social members as well as the principal magistrates. The second most aspect is, the JJB, Mr. Himanshu, Mr. Ashish, everybody is here, that, we kind of assumed the role of police. And I'll explain how, because the new Juvenile Justice Act, has a provision, the section 77 of the JJ Act. So we embarked on a quest to ascertain that how many children are actually drug afflicted and who are giving them drugs. And we also gave directions for registration of FIR against those drug peddlers. So this inquiry with the child, when a child comes, we put him questions, we ask him, are you taking drugs, and from where are you taking the drugs, and we used to record his statement, and we used to send the copy of the statement and our order to the police, and the police used to register an FIR, and also arrests took place. So that role, which traditionally should be of the police, this is something what we assumed, and this is also a time-consuming process. So in JJB 1, and 3, we've got more than 70 FIRs registered under Section 77 of the JJ Act, which is a very, very potent weapon to actually reduce the number of CNCPs in the first place, because we all know it is CNCPs who ultimately become CCLs. So that is one thing. Then, one aspect with Ms. Urvashi is also there. I think the Delhi, took the first step, the pioneering step to incorporate the concept of restorative justice. So if you recollect that particular matter where we made the child who had stolen a motorcycle of a person, so the victim was explained the circumstances under which he committed the offence, and the perpetrator, the CCL was told that, you know, your action has caused this ramification to the victim. So that restorative justice process also took a lot of time. More importantly, the JJB gets into a rehabilitation process. So there is economic rehabilitation, there is educational rehabilitation, there is therapeutic rehabilitation. For economic rehabilitation, you know, the amount of steps that a JJB has to do, you know, speak with the child, get the DCPU activated. We used to coordinate with the national NSDC, National Skill Development Council. So we used to send our children there, follow up, get him a 300 hours program, and under the aegis of the Honorable JJC, we even got a lot of children, you know, employed in Trebo, in King Burger, etc. And we let them off, you know, even if their remaining term was, it was remaining, still we let them start life afresh. Also, we passed orders to get Aadhaar camps, regular Aadhaar camps conducted in the homes. And one of the fundamental roles is also of getting a preliminary assessment conducted. So that process also takes time, because you have to interact with the person who's making the social investigation report, with the probation officers, then with the CWPOs who make the social background report, then the preliminary assessment report, then the psychologists. You know, then there are times, many a times that we do counseling, individual as well as joint counseling. So this entire means I can go on and on, but I think you get the drift, that there is a whole lot of work that a JJB has to perform. And but you are right, this is what is, but what ought to be is something which I fundamentally agree that there are miles to go. There are still miles to go. And now when we have a number of JJBs, I'm sure that, you know, the next time when you launch this report, the Delhi will give you a good, phenomenal figure.
I hope so. I hope so. I just have one round of final questions for everybody in terms of suggestions on the way forward now. I'll start with Mr. Kant. So you were also the founding chairperson of the DCPCR. Do you have any suggestions on the role of state commissions and how they can play a role in either oversight or monitoring or ensuring that these situations start to improve?
No, I think the state commissions are very much responsible, directly responsible. It's part of their duty to find out from jails, from various homes, and they are supposed to inspect also, like JJB does. I think this role is all pervasive. And they are supposed to ultimately enforce UNCRC rights, because UNCRC rights under the Commission for Protection of Child Rights Act, all these 54 articles of UNCRC, they become justiciable in India, isn't it? I mean, that's how the situation is. So this justiciability of these rights and these situations are bounden duty of the State Commission or the National Commission for Child Rights. One point I would like to say that, which I understood during my tenure as chairman of Child Rights Commission only, that the child has always a guardian. The child is never without a guardian. I mean, the law is very clear, sir. I think you'll accept that less than 18 years of child, you know, he has no right to property, no right to legal action, no right to marry, no right to drive. So the child is always in some kind of legal obligation. I mean, he is under some kind of guardianship. So each step where the child is traveling, not only police, let's say voluntary organization coming in contact, we are coming in contact. You did what to Rashmi is something, you know, which should be very, very common. It should be very, very common. So you are Rashmi, is it? He is Rashmi. That's correct. So now this is, I mean, I'm talking of your organization. So each step, if the child has a guardian, that guardian has a legal responsibility, in my opinion. That's why I said JJB is not the only one. Each one has to ensure, if the child is in a court, the court has to ensure. The child is, if it's a voluntary organization, the child is with helpline, the child happens to be in child welfare committee, everywhere, it is the duty to find out, to ascertain the age, which is very, very important. And age ascertainment again has a clear legal process. Anant will stand, everybody knows about it, that those three primary ways of finding out the age. Number one, You must get the certificate, the birth certificate. Number 2, if the child has gone to school, the school certificate. Number 3, if it fails and the child looks like a person, looks like a child, you have to get it ascertained through what our gentleman from jail, he said, that it has to go the medical examination or bone ossification or whatever. So these are something which are very essential things which need to be done by all concerned. That's my point. Okay.
Anant, as a representative of the legal community, what do you think that lawyers can do, and what can legal stakeholders like NALSA do in trying to improve the scenario?
नालसा ने तो अभी किया ना कैंपेन पूरा एक, उसमें बच्चों को आइडेंटिटी, लॉयर्स का हमको लगता है कि see, I did this high court matter, and before me there were other lawyers who did Supreme Court matters. I have lost hope in these mega cases जहाँ बहुत ब्रॉड व्यू लिया जाता है. आई थिंक अब मेरे लिए खुद का एक मैसेज है और लर्निंग भी है, रीच आउट टू द लार्जेस्ट नंबर ऑफ पीपल हु नीड दैट इंडिविजुअल लॉयर. जो यामिना ने किया कि वो गई वहाँ पे दासना जेल में ना, दासना जेल में गए और आइडेंटिफाई किया, उनसे मिली, उनका केस टेकअप किया. इस प्रोसेस में हमको बहुत होप है और इस प्रोसेस में लॉयर्स को बहुत जिम्मेदारी से करना है, क्योंकि जो बेंच पर जजेस बैठे हैं ना, उनको भी एक्सेस नहीं है बहुत सारे पर्सपेक्टिव्स की, बहुत सारे इन्फॉर्मेशन की. तो अल्टीमेटली ये जिम्मेदारी लॉयर्स की बनती है कि वो बेंच को एजुकेट करें और उनको वो नेसेसरी पर्सपेक्टिव्स प्रोवाइड करें थ्रू लिटिगेशन. ये सिर्फ एक बच्चे का एज का क्लेम नहीं है, ये कैसे इम्पैक्ट करता है पूरे जुवेनाइल जस्टिस सिस्टम को. बच्चों का जेल जाना वो बच्चों के लिए तो गलत है ही है, लेकिन जुवेनाइल जस्टिस सिस्टम को डैमेज करती है ये प्रैक्टिस. ऑब्जर्वेशन होम्स में जो बहुत वायलेंट कल्चर है वो सब इस प्रैक्टिस की वजह से आती है. और मेरा बहुत स्ट्रॉन्ग बिलीफ है कि जब तक बच्चों को जेल भेजना बंद नहीं किया जाएगा, जुवेनाइल जस्टिस सिस्टम कभी भी खड़ा नहीं हो सकता, क्योंकि सारे ऑब्जर्वेशन होम्स में जो कल्चर ऑफ वायलेंस है वो इन्हीं बच्चों के थ्रू जो कुछ न कुछ टाइम जेलों में बिता के आते हैं. तो लॉयर्स का, चूँकि क्रिमिनल जस्टिस सिस्टम के दरवाजे पर खड़े हैं लॉयर्स, और इसलिए बड़ी जिम्मेदारी बनती है, चाहे वो लीगल एड के लॉयर्स हों, चाहे वो इंडिविजुअल प्राइवेट लॉयर्स हों, एनजीओज़ के लॉयर्स हों, इस सब्जेक्ट के ऊपर उनकी अंडरस्टैंडिंग बने, इंडिविजुअल लोगों तक रीच आउट किया जाए. इनकार्सरेटेड लोग हैं, अभी अरुण सर ने कुछ टाइम पहले ही अपने जेल विजिटिंग लॉयर्स को बैठाला हमारे साथ, और हम लोगों ने बहुत टेक्निकल एस्पेक्ट्स पे बात की कि वो एज क्लेम कैसे करते हैं सेक्शन है. हमको लगता है उस तरह के बहुत सारे एफर्ट्स अपने लॉयर्स की कैपेसिटीज़ बिल्डअप करने पे, कि सेक्शन 9 की जो पिटिशंस हैं उनको कैसे ड्राफ्ट करना, कैसे उनको आर्ग्यू करना, राइट, वो सब बहुत ज़रूरी है. सो आई विल से कि रीच उस सेक्शन तक, लॉयर्स तक की बढ़े, और लॉयर्स के लिए आसान है इस सेक्शन को रीच करना. जो लोग जेलों में बंद हो गए उनकी फैमिलीज़ ही बहुत मुश्किल से रीच कर पाते हैं, और रीच करते भी हैं तो वो एक दीवार होती है, ज़्यादा बातचीत हो नहीं पाती है. लॉयर्स बहुत आसानी से रीच कर सकते हैं उसमें. तो लॉयर्स की तो बहुत बड़ी जिम्मेदारी है. बहुत ज़्यादा होप हमको, एज आई सेड अगेन, कि सीधे 1-2 केस पकड़ करके और उनके ऊपर PIL लगाना या कॉन्स्टिट्यूशनल कोर्ट्स का जुरिडिक्शन इन्वोक करना, हमको लगता है कि इस इशू पे बहुत टैंगिबल रिजल्ट्स ना तो लाया है अभी तक. 1983 से लेकर 2011 तक तो हमारे पास जजमेंट्स के भंडार हैं, और उनका इम्पैक्ट आप देख ही रहे हो. आई थिंक टाइम फॉर expanding the lawyers outreach to the affected population and take up their cases in individual courts.
Thank you, Anand. Speaking of jails, Mr. Gupta, आपके हिसाब से जो इंस्पेक्शंस चलते हैं, क्योंकि आपने इतने सारे देखे होंगे अपने टाइम में, उन इंस्पेक्शंस का इम्पैक्ट हम कैसे बढ़ा सकते हैं? Do you have any suggestions for how the statutory inspections that are regularly meant to be carried out, how they can be made to be as effective as they can be?
What is happening कि Session Judge साहब, he is visiting the jail. When he is visiting the jail, he is interacting with the prisoners and he is listening their problem and side by side noting the problem so that may be incorporated in his report. Even though this juvenility is the first point in his, but he is simply asking the ward in charge, who is assistant superintendent, कि भाई आपके पास कोई वो juvenile तो नहीं है? If he say कि
बच्चों से बात नहीं करते हैं,
सभी से बात करना भी पॉसिबल नहीं होता, क्योंकि काफी बहुत
जैसे
बड़ा
रश्मि ने अपनी कहानी कही,
हाँ,
तो वहाँ तो आए होंगे ना जजेस, लोग आए होंगे।
हाँ, ये कह रहे हैं कि इन्होंने बताया, जैसे इन्होंने कहा है कि इन्होंने बताया, पर उन्होंने को उस पर ज़्यादा नोटिस किया नहीं। तो होता क्या है,
सिस्टम ऑफ रिकॉर्डिंग,
हाँ, वो रिकॉर्ड करते हैं, उससे रिकॉर्ड करने के बाद अपनी रिपोर्ट देते हैं। देखें क्या होता था, धीरे धीरे सिस्टम ना डाइल्यूट होता जा रहा है, जितनी नई जजमेंट आ रही है, पर धीरे धीरे सिस्टम फिर वहीं का, जब हम देखते हैं ना 50 साल बाद जाके देखते हैं वहीं खड़े हैं जहाँ 50 साल पहले खड़े थे कई चीज़ों में। इसमें जैसे जुवेनिलिटी की बात है, अब जज साहब ने उसमें कह दिया कि कोई जुवेनाइल नहीं है। उसके बाद क्या होता है कि रिपोर्ट चली जाती। पहले क्या होता था कि एक हाई कोर्ट की बेंच होती थी, जो जज साहब की रिपोर्ट होती थी वो हाई कोर्ट की एक बेंच के पास जाती थी और वो बेंच उसको कंसीडर करती। तो मैं जाता, क्योंकि आई वाज द लीगल एडवाइज़र, तो आई यूज्ड टू बी प्रेजेंट देयर, और जो जो पॉइंट जज साहब ने लिखे होते थे वो सारे पॉइंट थ्रेड बेयर, दीज वर डिस्कस्ड इन दैट, वो डीजी प्रिजन यूज्ड टू बी देयर। तो उसमें अगर कोई जुवेनाइल वाली बात आती थी, अगर जज साहब ने किसी का लिखा है तो उसके ऊपर काफ़ी स्ट्रिक्ट एक्शन लिया जाता था। पर धीरे धीरे मैंने देखा है कि जो पहले जो कमेटी होती थी हाई कोर्ट में, अब वहाँ पे शायद कमेटी नहीं है, या कमेटी है तो वो बुलाते नहीं हैं। जो भी जो रिपोर्ट होती है सेशन जज साहब की, वो उसको सीक्रेसी में डिस्कस करते हैं। पहले ओपन में डिस्कस होता था। एक तो ये है कि ओपन में डिस्कस हो तो उससे क्या होता है, एक सीरियसनेस आती है कि जो भी रिपोर्ट है उसमें सीरियसनेस आती है और एक्शन होता है। दूसरा क्या है कि जैसे आज पता लग गया कि जुवेनाइल जो है जेल में है, अपेरेंटली वो है, एज बेशक जो भी लिखी है, पर वो लग रहा है कि वो एज से कम है जो एज वारंट में लिखी हुई है। तो आपको क्या है कि आप भेजते हो केस उसका सिविल हॉस्पिटल में भेजोगे, सिविल हॉस्पिटल वाले कई बार 2-2, 3-3 महीने ले लेते हैं उसकी रिपोर्ट देने के लिए, और तब तक आप बच्चे को जो है, अगर वो बच्चा है, अगर सपोज इज जुवेनाइल, आप उसको 3 महीने तक सॉलिटरी कन्फाइनमेंट में रख रहे हो, आप दूसरे प्रिजनर से उसको जो है दूर करके उसको रखा हुआ है। एक तरह की, मैं तो कह रहा हूँ, डुअल पनिशमेंट हो जाती है बच्चे के ऊपर कि जब आप उसको जेल में रख रहे हो। या तो इसका एक वे आउट ये है कि अगर कोई भी डाउटफुल केस है, उस बच्चे को जेल में ना रख के कोई और एक जुवेनाइल होम में, ऑब्जर्वेशन कहीं भी उसको रखा जाए, ताकि जेल में उसका एक्सप्लॉयटेशन ना हो। जेल में एक्सप्लॉयटेशन होने के चांसेस बहुत ज़्यादा होते हैं, जबकि और जगह शायद एक्सप्लॉयटेशन होने के चांस इतने नहीं होंगे। तो इसकी अगर टाइम बाउंड एक वो हो जाए कि जब सिविल हॉस्पिटल में आपने केस भेजा है, जेल से आया है, तो उसका इतने टाइम में जो है, मैं अभी आपकी रिपोर्ट देख रहा था, 3-3 महीने जो है, 3-3 महीने तक उसको जो है जेल में रखा गया है, क्योंकि उसकी रिपोर्ट नहीं आई। तो इसके ऊपर अगर कुछ किया जाए, कोई टाइम बाउंड इसमें हो जाए, प्रोग्राम हो जाए, तो शायद जो जुवेनाइल इतनी देर जेल में रहते हैं शायद वो नहीं रहेंगे। दूसरा, पहले जैसे होता था कि सेशन, पहले खाली एक सेशन जज का एक इंस्पेक्शन होता था। उसके बाद 2011-12 में हाक ने विजिट करना शुरू किया जेल में। तो मुझे खुशी होती है बताते हुए कि जब इन्होंने NGOs ने विजिट करना शुरू किया जेल में, इतने सारे इन्होंने जुवेनाइल्स डिटेक्ट किए। जैसे आप अभी 700 लोगों का बता रहे थे कि हमारे यहाँ से वो हुए, तो NGO के इंटरवेंशन से भी जो है बहुत ज़्यादा फ़र्क पड़ा, कि क्योंकि जो सीरियसनेस जो जेल सुप्रीम को दिखानी चाहिए थी, जो वो नहीं दिखा पा रहे थे, NGO के जेल में जाने से वो सीरियसनेस सामने, उन्होंने जब NGO ने पॉइंट आउट किया, उन्होंने सारे प्रिजनर्स को देखा, खासकर जो एडोलसेंट वार्ड होते हैं उसमें उन्होंने देखा जाके, और जब उन्होंने पॉइंट आउट किया कि ये जुवेनाइल लग रहा है, तो उसमें से 50% से ज़्यादा केसों में जुवेनाइल ही निकलते थे। तो ये जो NGO का इंटरवेंशन है, ये थोड़ा और ज़्यादा हो जाए और दूसरी चीज़ें अपना हो जाए, मेडिकल रिपोर्ट वगैरह टाइम पे आ जाए, तो इसको हम काफ़ी हद तक जो है रोक सकते हैं इनको जेल में रखने से।
Thank you, sir. And finally, I'm mindful of time, so I'll ask you to, if you can briefly just give us a couple of best practices. I know that you've recently, Mr. Verma, organized some trainings as well, but is there any other couple of best practices you'd like to share with us in terms of your suggestions? Thank you.
See, मैं 4 उदाहरण दूंगा, 4 examples of how the judiciary can play a vital role in addressing this issue of identifying children who are incarcerated in adult jails and how to transfer them to where they belong. So in my capacity, first example is in my capacity as a principal magistrate of Juvenile Justice Board, as has been discussed, that many judgments flow from the Honorable Apex Court or the High Court, but it is we at the grassroots level that we have to give teeth to those judgments. We have to ensure their implementation. So this writ petition 8889/11, it says that all age declaration orders from CWC and JJB have to go to SJPU. Now what I found, that more than 700 cases, the age declaration orders had not gone to the SJPU. So with one order to the joint CP, all the IOs came in 2 days. They took the age declaration orders from the JJB and updated the records there. So this is a vital practice that all JJBs across the board can immediately do. They can get this updation with the SJPU so that another child may not be, if he repeats, he may not be sent to jail. That is number one. Number two, when I was the Chief Metropolitan Magistrate of Delhi, then I remember the date, it is vivid, it is December 19, 2019, that when anti-CAA protests were going on in the country, so a lot of youth along with children, they were detained in police station Daryaganj. So I remember the advocates could not reach out to the duty magistrate or the metropolitan magistrate. So since I was the Chief Metropolitan Magistrate, they came to my residence at midnight, and at midnight I passed the order that the juveniles will not be kept in the lockup at all. So because I knew that the lockup is an extension of the jail, and because of that order, within a couple of hours the children were released. So that is a second live example I would tell. The third example is that after being promoted as a sessions judge, I was also appointed as a jail visiting or a jail inspection judge. And all these, what I'm saying is, I have got the orders and I've got the reports as well. So in that inspection, one inspection I did, I identified 4 children, and I immediately directed the jail staff to take these 4 children to the legal services. There is a clinic in each jail. There is a legal services clinic, chakkar kehte hain jisko. So take these children there and get their applications moved. So that is just because it's visually you can make out that these are and also in jail number 5, there are each jail, as you are aware, that there are different wards inside the jail. So there was ward number 9 where a high risk prisoners cell was also kept. So imagine in that jail number 5, which is supposed to house adolescents, there dreaded terrorists and convicts were kept. So in that inspection report, I wrote to the DG Prisons that according to your revised lodging policy, jail number 5 is only for youthful offenders. So because of that report, sir, they shifted that high risk prison out in 2021. Now again they're again building it there. Again I have written a letter. Now because I'm the secretary of the Delhi High Court Legal Services Committee. So in this role, what happens is we send our jail visiting advocates. So we've got some 40 jail visiting advocates visiting each jail. So recently Mr. Asthana was gracious enough to come to our High Court, and he explained to all the jail visiting advocates that when you go to the jail, just don't sit at the legal aid clinic. Go and visit each and every barrack, go and visit each and every Mulaiza ward, and especially the Mulaiza ward, that is the reception ward. And when you go there, interact with the children and tell the jail visiting advocates how to identify children, the steps and how to do an age inquiry. So this session wasn't just about awareness. After this session, I have taken out an office order and I have impressed upon all the jail visiting advocates that after each visit, you have to tell me how many children have you identified and what steps have you taken, because the moment they come to us, then we can again send it to the DLSA to move applications. So these are actionable points which I would like to tell before all of you. Thank you.
And that's a fantastic positive note to end this panel discussion on. We have a paucity of time, so we're going to be taking limited questions at this point, but does anyone in the audience have a question for the panel? We'll also have the panelists here after the event is over. In case anyone would like to speak to them individually, you're more than welcome to do so, and I'm sure they'd be more than happy to share their experiences with you further. At this point, I'd like to invite Justice Bhat to give his keynote address to all of us. We can stay here. Justice Bhat needs no introduction, but nonetheless, I will, for formality's sake, give him an introduction. Justice Bhat is a former judge of the Supreme Court. He was also the former chairperson of the Supreme Court Juvenile Justice Committee. And in that capacity, he's very sensitive to these issues, and he's so graciously agreed to be here with us today to share his opinions and his thoughts. So we're very grateful to him. I'll hand over to Justice Bhat at this point.
Good afternoon. It's a pleasure to be here amongst you, back to the juvenile justice segment. Yeah. And I thank iProbono for this. I have 2 points of reference. One is iProbono. I was one of the, I think early, probably I had attended the event, and when the first inaugural event, I was made a guest of that. And the second is that juvenile justice is dear to my heart, and I have been in this movement, if I may say so. The introduction has been brief, and it should be, but like Mr. Kant and Mr. Asthana, I would say, Mr. Asthana, it's a nice feeling to be back amongst our friends, and Mr. Asthana is one of them, and Arul and Mr. Kant also. Well, I was not just Juvenile Justice Chairman, Juvenile Justice Committee Chairman for 4 years, but I have been in this juvenile justice movement from even perhaps the time that many of you were aware of. It began with Sheila Barse's petition. At one time, Sheila Barse got, as she described it, frustrated with the Supreme Court and the number of hearings which took place, and she called it dysfunctional, and she said that I wish to withdraw the petition. So the Supreme Court, in an order, said that you can't withdraw, it's a public interest litigation, but if you want to withdraw yourself, we'll do so. But then who was to conduct the litigation? So the Supreme Court sent it then to the Supreme Court Legal Aid Committee. We are talking of the pre-1987 situation, no, pre-1987, when you had the Legal Services Act. And the I would say thanks to the efforts of Sheila Barse, the 1986 Act got enacted. And the 1986 Act was not operational, which was the reason why Sheila Barse moved this petition, and it went on for so long. So the the Supreme Court Legal Services Committee needed a lawyer to constantly monitor the litigation, and the committee was receiving reports, monthly reports from every district, and you can imagine even those days there were 400 odd districts, and somebody needed to sit over these. So there were of course few lawyers, but then I was made in charge, I was put in charge of this, and for about 3 to 4 years I used to prepare summaries and had a detailed dossier of the orders, and a series of orders were made to set up the institutions under that committee. Then, as they say, cut to 2000, and the act which Mr. Mr. Amod Kant pioneered, and then of course 2016, the rest is history. But coming back personally, in 2011, around the time Justice Sikri was the acting Chief Justice, he put me on to the Juvenile Justice Committee, and I continued in that, and I chaired it for about almost 6 years. For a brief, there was a brief break for about a year and a half when I was not the chair there, but then when I came to the Supreme Court, within I think 3 months I was made a member of the committee, and then from 2019 December or January 2020, I chaired it. So a lot has happened, but there's a lot to be done. This is what I would say. The report gives out certain stark facts, and I think we have to really be thankful to Gitanjali and the other members of our team and iProbono for coming out with this unique report that we have. Between 2016 and 2021, we had at least 9681 children in conflict with law. Now, I will not speak as much about the report and what it has portrayed. It has portrayed a lot of things, some things even with the limited number of responses that the report has pointed out are pointers to a lot. UP, the largest state, reported, the compliance report is that there was 74% response to the RTIs, and what is revealed is that the total number of visits to these institutions or the jails were 90 by the JJBs, by the juvenile justice boards, and 2,914 children were transferred from jails. Likewise, then we have this other stark figure of Madhya Pradesh and West Bengal, who did not respond at all. Then we have interesting details, and these details, the nuances of these, the granular points actually are very important. Telangana shows 100% compliance, and there were very few children to be transferred. And even more interesting is Tamil Nadu. There were 56 visits, 38% response, and 56 visits and no transfer, which could mean two things: that there were no children in this 56% response, or that there were children but not identified and waiting for the process of identification. Haryana also has shown a startling level of compliance, which is 90%, and there were 83 JJB visits and 1621 transfers from jails to JJBs. Now, the interesting two details which I wish to share from this experience is, what did Rashmi undergo? Rashmi said that the police noted down my age as 19, though I was 17. आपकी उम्र आपने 17 बताया था, लेकिन उन्होंने 19 लिखा. Secondly, which means that the police has a mindset. The second aspect is the judiciary failed. We all say this is the contact point. I think Arul made a very telling point. The contact point for our liberties is the judge before whom the prisoner is produced for the first time within 24 hours. The usual suspects are police. Of course, they have a role, but equally I feel judges have to play their role. Often visual inspection, confirmation is just possible that this person is not an adult, he or she is a child. Now that is the second failing. The third failing is at the point of time of entry into jail. Now that is where the boy or girl is produced, and that too is the point where possibly the child might say, I am a child. That is where the jail authorities, there is an uncritical reproduction of what the police has brought in. And then of course the fourth point, at the point of production in court and reiterate, the visits, even in the visits there is a mechanical point inspection undertaken. Perhaps one way of looking at it is that there should be a separate column in each FIR, which of course has the date. It is necessary for all stakeholders to arrive at some, this is a very important point. How do you collate this 18, 19, 20? There is a suspect age group. This suspect age group is the one. No amount of inspection in juvenile OH is important, nor asking the Juvenile Justice Board, which may or may not conduct periodical inspections and looking at the kind of let's say erratic responses in various states. I think it is important to arrive at one point. That one point could be the suspect age of 18 to 20. There should be a scrutiny at the different stages. At the stage when the child is produced before the magistrate, at the stage when the child is remanded, at the stage when the child comes up again for confirmation of remand. And I don't agree at all with Mr. Kant that the local guardian, the guardian has the responsibility. Most frequently children and guardians and even prisoners don't know what their rights are. Who knows about the Juvenile Justice Act? Who knows about the fact that children cannot be sent to jail? Even those who might be educated are unaware. Though we may run campaigns of Nalsa, I think that whatever we do is not enough. So therefore it is, and the most importantly on that point, I completely disagree that again it's the citizens' responsibility, it's the responsibility of the state. Because the state, we say in law, Mr. Asthana knows it, all of you know it, men and women of law, the state is parens patriae. The state is the parent. If the state is the parent and the state is stealing the childhood, I would say that, because that is no less than that. If the child's childhood is being stolen away by the state, the least it can do is to improve the system. We are all participants in the crime, if I may say so, the police, the judiciary, the jail, and asking the civil society to step in and assume greater responsibility is not just done. It is the state's responsibility, and we have to evolve a better situation where identification is possible, provision of legal aid is possible, and then ensuring that the matter is taken forward. So in that sense, this kind of accountability by just presenting the information and the powerful use of the RTI is really pioneering. I would really commend iProbono for this. I would expect all of you to give them a hand. Many speakers have spoken about NALSA's recent national campaign, which is known as Restoring the Youth, which is aimed at identifying juveniles in prisons and providing them with essential legal assistance. Now, coming to the point of inspection, which I think Mr. Gupta made, it's a very important one. That is, when sessions judges go there, I don't think there is a set mechanism. We don't have a framework of inspection. So the identification of the cracks through which these juveniles, or what we call them as juveniles or children in conflict with law, slip through and get into prisons is very important. One I pointed out is where the child is produced, where the FIR is recorded. If that is the problem, that is one. The second is the strict accountability even of judges who do not show the sensitivity to inquire into the child's age at the time of production. They should talk. I think a couple of speakers have made, I think Mr. Asthana made the point that they don't even look up. Now I think any child who is produced, if he is proved to be later a juvenile and not an adult, there should be some accountability from the judge. And I think unless it's a borderline case where it is 17 and a half or something like that, and sometimes it's possible that children look older. But if it's an obvious case of a 16-year-old or under, I think there has to be a penalty. Likewise, there has to be accountability to the police, accountability in jail. And I believe, and I think Mr. Asthana made, I think Gitanjali made the point that a 500 rupee fine isn't sufficient, and the individual is not disincentivized from doing what he does. So therefore, I think we have to visualize more accountability. I would even use the what is done in the West, that there has to be a monetary accountability. The government has to be sued, the government has to pay compensation. We just don't take the government or the state or even the individual to account for his or her action. Penalty and damages is the only way. A crippling compensation direction or a decree is important. How we can achieve it, how we can ultimately get that is a whole story altogether, but I think the idea has to be seeded that this is important. And before I end, I just want to make one important point. We have been talking of children in conflict with law. What about children who are not in conflict with law? What about those children who are in jail because their mother is in jail, or because they were born there? According to we don't have again any system of annual accounting for this, but a study conducted in 2014 said that there are 1900 such children across the country in jails, and who are not juveniles, who are not accused, but just because their mothers are under trials, and perhaps there is no other caregiver in case the child is taken away. So, and I have seen this. For instance, I went to an open prison. An open prison is actually a heaven compared to the other kind of prison, where I could see mothers and children having a school inside the open prison. Now that's an ideal situation, but the point I am making is they are not children in conflict with law, they are children in need of care, and they have to be located and placed somewhere. Now the last aspect which I wish to just highlight is children in jail, whether as juveniles who face the juvenile system and are either prosecuted, acquitted or convicted, or children who innocently live in jail till their parents or mothers are released. There is an enormous social and psychological cost. There is no quantifiable material, there is no objective framework of assessing that cost or the impact on these individuals and the impact that is going to be felt by society. I think it is high time that we recognize this. I would end this by saying that empirical knowledge is information, and information is valuable for A, the result it presents us, and the nuances of all the issues. B, the remedial steps which we take. The dismal though the facts are, one should be positive about the takeaways. One, more education and capacity building, which is needed at all levels, at the level of the police, I would say at the academy, police academy. I am sure there is a stronger move to educate the police, and I hope there is, but not just in one state or one city, but across the cities. And this is where I believe institutions like the National Police Academy, the National Judicial Academy can collaborate and come out with better.
Sir, I was in police secretary just about 15 days back.
Right.
So I find that their awareness about the entire situation is far behind.
Yeah. So there is a constant. This can't be one point. This has to be at different levels. And I believe there is, in this part of the training, we also need to sensitize the bureaucracy, as at least the Department of Social, the Child and Welfare of all the states, I would say the finance ministries, to ensure that there is greater funding for education, in the sense that it is important that you send these administrators, these police, some of them abroad, and show them the ideal systems in Sweden or in the Scandinavian countries, how this has run, so that they come back with ideas and are sensitized. It worked, it has worked in some states in the field of education. Then we have to, of course, there is the sensitization of police and judicial officers is an ongoing project. It is not a one-time project. And information dissemination to the general public. It is not again about what? There have to be capsule. You have to have slogans about juvenile justice. What are the rights of children? I would say when you talk of juvenile justice and juvenile courts, far too much is spoken. Do we have amicus? I know that in Delhi, in the JJBs, every JJB had one or two defenders who were appearing on behalf of the juveniles. The question is, do we assess them? What is the kind of workload they have? Can they deliver? Can they be effective? And so on and so forth. And likewise, we have to create more such officials. And when you talk of information and dissemination to the general public, the awareness in a brief manner that children are not adults, children are different, children have to be tried or dealt with differently. They cannot be in jails, they cannot be sent to the normal courts. And lastly, deeper inquiry into the social, emotional and psychological impacts of children in prison. Children in prison, whether they are in conflict or unjustifiably incarcerated or are born or raised in prisons, are victims of a mindless, I would largely characterize this as mindless, because there is a bureaucracy. It's a Franz Kafka-like situation, because once you get entered in as an adult, not a child, the whole system repeats, and there are biases, inbuilt biases also. They are all victims of a mindless system because they either lose hope or have no vision. That's we heard very poignantly from Rashmi that at one point he became he was in despair, and they are denied all those rights, facilities and opportunities which each citizen, each of us takes for granted. I would congratulate iProbono for this pioneering effort and hope you keep this, and hope that several others take this up and make it their mission. Thank you.
Thank you so much. Thank you for that, Justice Bhat. I think a few of the suggestions that you made really resonate with us. You mentioned the issue of compensation and trying to get compensation for these children. What Justice Bhat did not mention was that when he was in the Delhi High Court and there was a child before him who had spent time in prison, he granted compensation of 5 lakhs to her, to him, sorry. And that's a precedent that we rely on very heavily in our work. Upheld the acquittal. But and that's the problem, that very often the path to getting somewhere is so slow and so granular. But it's something that we've been trying to do as well at iProbono. We've been trying to move compensation applications for children in these positions. We've been trying to actually get action taken against the investigating officers in situations where a child has said that they've told the police at the time of arrest and no action was taken. So we hope that slowly and surely things start to improve. We hope that if this report takes place again 10 years from now, the data will be much more encouraging. And we hope that hearing stories like Rashmi's will make it very clear that this is an important issue that needs to be dealt with. I'd just like to end by thanking all of our panelists today for their suggestions. It's wonderful to hear some of the best practices that are being implemented. It's helpful to hear some of the thoughts and suggestions of how we can move forward, and I hope the system takes these suggestions on board, and I hope that reports like this continue to highlight the issue. And of course, without the support of senior and sensitive stakeholders and allies like Justice Bhat, none of this work would be possible. So once again, I'd like to thank him and the panelists and our team for their fantastic work. I hope that together there is some scope for improvement in this space, and in the years to come, many of the measures that we've discussed as best practices start to be implemented. Thank you.